Hi, everyone, and welcome to the next session and getting down to the end of the day, but hopefully an exciting session here with Loretta, Joseph, and Joey Garcia. Uh, Josh is having some technical difficulties, and hopefully she'll be able to join just momentarily. But during the session, we're looking at legal and regulatory frameworks for Bitcoin reserves. I personally think that this is a larger question that is not just for Bitcoin reserves, but also encompasses, market structure bills and things of the sort when it comes to that. But before we dive in, I wanted to quickly have the panelists introduce themselves. So, Loretta, would you like to take a minute?
Hi everyone, my name's Loretta Joseph. I consult many governments and regulators on virtual assets and virtual asset service provider legislation and regulation. I was the expert lead on the Commonwealth model law on virtual assets last year. I wrote some of the first legislation in the world in Bermuda in 2017 on digital assets and on ICOs. Since then, I've done work across Nigeria, Sub-Saharan Africa, Mauritius, Vanuatu, and a number, I think 17 countries in total. I've written regulatory and legal frameworks for crypto assets. So that's me.
Thanks.
I'm
Welcome,
in
Joe.
Jamaica.
I'm the Chief Digital Asset and Legal Officer at Xapo Bank, which is a blockchain and Bitcoin native bank, a credit institution. Been in the space for a long time. I also act as the specialist consultant to the United Nations, so I help train and assess sort of gaps and developments, mainly in Southeast Asia and the jurisdictions around that region. I was part of the Libra DM initiative, and in the US, part of many think tanks and working groups. So spent a lot of time with the authorities from the West in one block and from the East in another block. So good overview. And then focus my time mainly now in the UK.
Wonderful. All right, so let's dive in. Earlier today, I was on a different panel here for the conference, and a lot of that panel was talking about the Bitcoin reserves or strategic reserves that Donald Trump set up through his executive order earlier this year. And I pointed out that, there is some misunderstandings there because it is not actually a strategic reserve. Oh, hi, Josh. Josh, welcome. I know you're being late. We've already dived in, so I guess when we direct the first question to you, I'll have you introduce yourself quickly. But just in the interest of time, going to proceed with the opening. Um, so with the strategic reserve, as I was saying, it was not necessarily a strategic reserve by law. It is a name only. It is essentially a stockpile. One of those follow-up questions that were posed to me in that was, well, when will this get done? And my response was, at least 2 years in my personal opinion, because the US can't get out of its own way and have, other important things to work out first in this area, specifically stablecoin bill and market structure bill, and then a whole host of other issues that are going on in the US that didn't come into like congressional timelines and things like that, even outside of crypto. Loretta, you have written legislation in a number of countries, as you just told me, is currently working on one in Jamaica. Can you tell us where does that where does Bitcoin reserve legislation globally fit into this structure of like having to get so many other things in line before we get there? And can you expand on that any?
Yeah, so I mean, legislation takes a long, long time. It's one thing to have an executive order, but you have to get these things passed through bills of parliament, and one bill can take up to 2 years. I just had the virtual asset bill passed in Vanuatu, and that's taken me 6 years to get it up. At the moment, I'm the expert lead for the Commonwealth Secretariat on the bill on stablecoins. We thought we were racing against time to beat the US to what we're doing, but to be honest, I don't think that they will get anything out in the next 3 months. We will have a draft bill for the Commonwealth, which to me is important because there's 2.8 billion people in the Commonwealth that have exactly the same law systems. They just have to tweak a model. It's just the minimum standards. It worked very well with our base umbrella law, the model law we did on virtual assets last year, and we've used that as our base umbrella law, so we can fit a lot more things into it a lot quicker because it's not a standalone bill. It feeds back into another bill. But I think, for me, legal clarity is really important. I think people forget about it when you're looking at key regulatory, infrastructure needs. You need legal clarity, you need institutional oversight, and you need monetary and policy and fiscal policy alignment. Those things are not easy to do overnight. So, I think you're very right that these things take a very, very long time, and to get everyone to agree, even in a small jurisdiction, as I said with Vanuatu, it's taken me 5 years to get a piece of legislation passed. But on the flip side, when we were in Bermuda, we passed the first ever digital asset bill in 2018. We got that through Parliament into bill in 8 weeks. So it just depends on the country and the size of the country and the appetite for risk of the leaders that are running those nations.
Yeah, and just to add to that, Brian, I mean, I'll just add, I mean, what you've seen in the world are, let's call it the FATF triggers in June 2019. The FATF is not a regulatory body or authority. They define standards around the requirements for a registration or licensing, but they didn't create frameworks for what those models should look like. So Loretta mentioned before, building out something like a prudential standard is extremely different to building a sort of an AML compliant framework for virtual asset service providers. It doesn't really matter how much AML FTX had run if you have core deficiencies in the safeguarding and segregation of customer assets, or just core governance principles that exist within any regulated environment. That's always going to create problems and issues. And then to come back onto the question of reserves or governments taking a view. I mean, lots of parts of different industries have started becoming more and more familiar with the virtual asset ecosystem and how it works and what it means. And governments are now almost in the beginning bucket of that, if you might say that. So understanding like basic core principles of security sounds very simple, but it's not actually that simple. So, I mean, the US will be an exceptional case, but there are lots of authorities, institutions, and groups in the world that are looking to exposure, but they don't really understand how to assess the risk of the counterparts that they're using. So that's also leading to lots of interesting security related questions and issues.
Well, I think it's an important issue. I mean, these laws you can't just do for AML CTF. Yeah, they have to include prudential requirements, consumer investor protection. FTX, I will argue, until the end of the earth, had nothing to do with Bitcoin. It was a poorly managed business. There was no fit and proper management. It had nothing to do with the asset. Sam could have been trading, jelly bean derivatives for heaven's sakes, and he probably would have been better regulated. So it's important that you look at things like that, and those other modules, because there are standard setters. You've got the FATF that does AML. You've got the IOSCO, which looks at consumer investor protection, and then you have the Financial Stability Board, which look at financial stability. You have to look at those three things in a bucket. You can't look at them individually because laws don't work like that.
Yeah. With all those agencies, I think one of the more important ones that I often looked at that haven't been mentioned and not are often mentioned are IOSCO for IFRS and GAAP standards for tax and accounting. One of the issues I've been talking about recently in different panels is, crypto typically and stablecoins are typically classified as property and not money, and everyone is treating them and calling them money or forms of money being used for money payments and everything, and that creates a huge gap when it comes to what will ultimately, in my belief, become like everyday use of these items for the purchase of goods and services and things of the sort. So what people often don't realize is every time they're using a transaction, that is a taxable event.
Yep.
And subject to capital gains and losses. If you're using USDC in London, you have to go through FX transactions, so there's double taxation, all sorts of things. So Joey, bringing all that back to you, what needs to change from those standards to make it adequate for Bitcoin to be held as a reserve asset by countries? And are there any specific reforms or disclosures you would suggest when governments are thinking about this?
Yeah, I think that's a good question. I'm just going to share something very, very quickly. So the starting point, because we started talking about security and then the sort of flow through to all of these implications and everything else. And I just wanted to show something very quickly, because everyone was talking about the US. In the context of a different jurisdiction of El Salvador, this is public information. It's the Bitcoin office of the country. Shows the balance within that address, etc. This is obviously public information. So if you then look at the address, you can see the transaction histories related to that wallet. That's all very interesting and also very public. A little bit more interesting is if you start to look at the actual the address is part of another wallet, so part of a kind of address grouping. We don't have any other information around that. So what we can see from this and what we can see from this wallet address and from what we can see from this is that we have a government authority that's probably using a form of multi-sig configuration arrangement for their own security standards. So again, I'm not going to comment on the infrastructure being used to maintain secure custody of those keys, but we're talking about a government authority gaining a balance sheet exposure to a virtual asset, in this case BTC. Do they have redundancy plans? Do they have single risk location risks? Do they have single points of failure within specific key holders or controllers? Do they have physical theft or coercion protections? Are they protected against supply chain attacks on those wallets? How do they manage insider threats? What are the software bugs and compatibility issues within the wallets that they're using? Have they planned around long-term Bitcoin protocol changes, which could require migration to new standards? Have they assessed quantum computing threats? So, I'm saying all of this stuff because we've learned bits from things like Bybit, etc., and the compromise of the safe wallet. That's developer machine sort of modified code to deceive the users, and that's highlighted lots and lots of critical vulnerabilities. So what exactly are jurisdictions doing to when they're gaining something like exposure, or even if they're using a pure custodian, a third-party regulated custodian? Again, what are the other considerations that they've had around centralized control, around diversification risk, around there are lots and lots of different factors. So these are like we're talking about really, really basic layers of the custody arrangement to hold an asset, and that's already creating a bit of a problem and an issue. Then when you get into the further question beyond that, and you start looking at central bank or government exposure from a tax perspective, you kind of touched on this already, Brian. The classification of the asset is a kind of starting point. Is it a currency? Does it fall within the commodity bracket, or is it a capital asset? Most people, as you say, are moving towards that kind of property definition. But taxation of transactions, taxation of capital gains valuations, reporting requirements, audit standards around proof of reserves, transaction auditing requirements, internal valuation auditing, regulatory clarity, international cooperation as to how it's being treated between jurisdiction A and jurisdiction B on a settlement or transfer basis. There are just too many things and too many complexities. So there's a big range of issues, right? We're talking about like basically holding the asset, all the way through to the sort of the tax infrastructure, and even the bits that we don't want to talk a lot about AML and CFT in the context of reserve. But yes, absolutely.
Well, if I can jump in there though for a sec, because I think you raised a few important points, Joey. But I think we've learnt some really hard regulatory infrastructure needs that came out of El Salvador. I think one was legal clarity. They declared it legal tender, but what are the broader legal frameworks we need to look at? How does it get treated under the central bank balance sheet, the sovereign debt instruments, the monetary policy rules? They're still very underdeveloped. Any country, I think, that's going to classify Bitcoin as a reserve asset has to legislate very clearly the accounting and valuation standards, as you pointed out. because it's akin to maybe gold or another, other foreign currencies, but not exactly the same. The institutional oversight is really important. And what I mean by that is, a sovereign Bitcoin reserve requires independent oversight. I think you need mechanics for public reporting, auditing, reserve risk management that shows transparency. And I think it sort of insulates the holdings from political cycles or speculative misuse, which you do tend to get in countries which are looking at. And I think the final thing for me on that is the monetary and fiscal policy alignment. Bitcoin is very volatile, and those challenges really challenge macroeconomic tools that we use today. The reserves have somehow or other got to be integrated into the broader fiscal planning. What are the stress test models, as you pointed out, by the custodians? How do you manage the liquidity risk? How do you manage the volatility shocks? The El Salvador experience showed that hedging tools are very, very important, and a very, very diversified portfolio is as important. But then it does trigger things like tax requirements, capital tax reserves. And I think a number of countries are looking at the El Salvador experience very, very closely. But you touched on the key element, which is the security, because if a country is going to be holding this, hackers are going to come after them with
Absolutely.
every available tool that they can find. I'm sure the North Koreans are on the job as we speak.
Yeah, no question.
May I just jump in with something about El Salvador just for a moment? Is that okay?
Yeah, of course.
Okay. So, by the way, hi, I'm Josh. I'm from Linklaters. So one of the things, as you've spoken about how El Salvador obviously went through a process of treating for a time Bitcoin as legal tender. I think what we need to remember, of course, is the ripple effects to other countries. And so one thing that really has come up a lot in the US, although perhaps now not because, of the position of the IMF and what El Salvador is doing with respect to Bitcoin, is that when you're dealing with very basic things like the UCC, the Uniform Commercial Code, which is a creature of state law, but it comes up in secured transactions of all kinds. So your basic secured loan to all sorts of off-chain settlement, things like that, is that once you have a nation treating a digital asset as legal tender, right, or adopting it as such, there are certain states, including South Dakota, where certain custodians are held, that will treat that then as electronic money, which is different from how they may treat what they call controllable electronic records.
Well, it's interesting, just on that point, it's interesting. In the law that I write for the Commonwealth, we actually state that Bitcoin is not legal tender. And that's written across 58 countries. So that's one thing we do state, which is the complete opposite to El Salvador, is not legal tender.
Yeah, I think it's just interesting how even one country's taking those actions can literally have an effect on certain state laws, which are very patchwork right now within the US. So sorry for that little interjection. It just
no, I think that's actually a good segue. Sticking with you, Josh, the states are one thing here in the US. Then, as Loretta, I'm sure you can agree, like even our federal laws are a mess most of the time, and there's a lot of ambiguities. There's a lot of things open to interpretation, and a lot of things passed down to agencies. And then we love our agencies. We have the SEC, the CFTC, the OCC, Treasury, this, that, the other.
FinTech, anybody else?
This is an industry that needs consistency given the global market. So what do you think what reforms do you think we need here in the US, Josh, to avoid this jurisdictional overlap that is causing all these problems or will cause problems in the future?
So are we sticking here to Bitcoin or more broadly? Because I think there's a couple of different answers. Okay, so I think with Bitcoin, we do have a unique position in so far as, both the SEC and the CFTC have long agreed that Bitcoin is a commodity and not a security. Whereas with other types of digital assets, there really has been a pull because the CFTC will say essentially nearly every digital asset is a commodity and has previously said, well, guess what? The test for whether there also may be a securities transaction is a different test. So as you guys have mentioned at a high level, within the US, there's a patchwork of regulators, all of whom, or nearly all of whom, have some type of angle and potential jurisdiction with respect to digital assets, I think the cleanest way really is to do what I believe our courts have been, in the process of doing, which is clarifying that the digital asset, if it doesn't look like a traditional equity security or debt security, right, where it actually is intended, because of course there's tokenized securities and things like that coming up to the fore, but that otherwise, the code is code, right? And so I do think that the CFTC is well positioned, to be,
A
to be
leader.
yeah,
Yeah.
to be the leader in that.
That's in the legal frameworks I've written, we've always said that Bitcoin's a commodity across, that's like 58 countries. So we're talking about 2.8 billion people here who now can have a consistent law that says Bitcoin is a commodity. But I think it's an important thing we've got to note, though, when we're talking about Bitcoin reserves. You talked about the FATF earlier, Joey. The problem is the FATF standards, when they came out in 2019, they were the first standard setter that came out with a particular definition of a virtual asset. And that definition was a digital representation of value that can be traded, transferred, used as a unit of payment or of investment purposes. If they considered it a security or commodity, it's already covered under other AML law. So this is where this is going to get tricky with the Bitcoin reserves, because under the FATF requirements, Bitcoin is traditionally not included to be a virtual asset service provider. But if you're using a risk-based approach, which the FATF demands that countries do, you're going to have a problem if your custodian is a VASP. So, the travel rule, recommendation 15 and 16 are going to apply, even if that's a reserve currency. So I think, while the reserve holdings might be exempt, the FATF is still going to encourage jurisdictions to assess their systemic and national security risks, particularly when their holdings are large and opaque. So I think that's going to be interesting in the US.
Yeah, it's not just, also from an AML perspective, like we were mentioning before, to give some random examples, like the Tornado Cash incident back in the day and the OFAC sanction of address XYZ, you had lots and lots of tainted assets and wallets, and there were very, very specific groups of people that were targeting distributions into pools to taint the assets of that pool, which could have been collateral for algorithmic-based stablecoin or whatever it might be, and they were or a DEX-related platform where they were looking to affect liquidity pool A, B, or C. And governments are honestly learning around how this works, starting with blockchain analytics and what that means, and managing the risk of an open address that's accessible by anyone to see any transaction and deliver any value from anywhere in the world. Sounds wonderful philosophically, but practically it can open up a lot of
but I think that technology risk assurance is the biggest problem. This is, if we're looking at the Bitcoin reserve, it's the biggest problem. And you mentioned it many times before, Joey, audits, they have to assess the cyber resilience, what we're seeing, the operational risk controls of wallets, the custody systems, do you mitigate the fraud, the hacking, the internal mismanagement. These things, nobody has actually, and the standards are only just starting to be developed. I work with a number of, when we're doing the stablecoin model law at the moment, we're putting in some really important standards around audits, like tech audits. These things are fundamental to what we're talking about, because if a central bank gets hacked, it's not like taking money to the banks. You try and work out what the macroeconomic effect of hyperinflation or deflation is going to be. It's really serious. So it has to be thought of with a very particular overview and from a prudential requirement view that includes technology, includes those sort of risks, the assurance risks, the tax issues about a central bank holding something that is considered in the UK, US by one state something different to another. That's the issue I think you have in the US. You have so many different regulators with so many different mandates.
Yeah, no, totally agree. And I, in the interest of time, just want to say, if anyone has any questions that they want to ask posed to the audience, please put them in the chat on the side. And we have a few minutes left here. I know Loretta has a very important call to get to, so she has a hard stop. But so, two questions, Joey. You've talked a lot about security on that aspect. Yeah, I read all these pieces of legislation, and I think this is very important for strategic reserves as they potentially become a greater part of the conversations. I don't see any standards that are being set yet that are enough to secure sovereign nations and sovereign entities to be able to properly secure. So what do you think is potentially the answer? And then Loretta, also going to something you said, and Joey, please, or Josh, please chime in here also, like on the auditing side, like I think this is something that is completely or I shouldn't say misunderstood, but not thought about enough. Is the reality is auditors and the traditional auditing firms don't have the capabilities or limited capabilities to actually audit these firms in the way that they want. And then you have, because I used to work in the New York Attorney General's offices, I led the Tether investigation, and I saw time and time again, Tether saying they don't understand how we operate, we can't be audited. And that's been like the standard. That has just been like, no one understands it, you can't do it. In my mind, it's more complex than that. I think if you, with the right tools, it is understandable. It's just a matter of entities and corporations and VASP being willing to turn over the information that it requires to get audited. So I know that was long. I know two parts. Joey, I will turn to you on the security side first. Loretta, Josh, think about the audit side, and we'll circle back before we close out.
No, I think there's going to be a base layer of like starting off. I'm just going to call it education, where groups or authorities need to learn what proper infrastructure looks like. I mean, if you show someone what a secure, MPC sharded with location continent base, where you've done geopolitical risk and the sharding of those keys in an infrastructure where you have only whitelisted addresses that a transaction that can be made to, you're talking about levels of security that don't exist if you just simply take a ledger device and create a multi-sig arrangement. And people, honestly, they don't understand. People don't fully understand how to conduct due diligence on a VASP. So they do it typically by way of Twitter feeds, the quality of the website, and a couple of famous people that talk about them. But the authorities need to start learning the infrastructure and process to assess risk in the appropriate way, and that will lead to the development of regulatory standards. But those standards moved so slowly compared to what's actually needed to support this. So I think it's going to be, the answer to your question is education, learning, infrastructure, trial and tested systems that are working, and the kind of copy paste approach to those, I think to a degree will start to happen.
And I think the biggest problem too is the word audit, because people think of accounting audits and cybersecurity audits are completely different. People get them very mixed up, as we do in crypto terms a lot. Like crypto exchanges in my mind are not exchanges like security exchanges; they're just matching engines. But so there needs to be things like fair value accounting frameworks. Reserves need to be reported using international best practices and standards. There is IFRS and I think IPSAS. I wrote that major. But they've got clear disclosure requirements on unrealized gains. Valuation methodologies need to be better. I think custodial arrangements need to be understood much better by the issuer, by the government. Independent audits on Bitcoin is really important, as Joey keeps mentioning. Like, to me, that's the fundamental problem here, is that audits, tech audits, are so much as important as financial audits. And I think, from exemption from capital gains is going to have to be really unpicked, especially in the US, because you've got conflicting tax treatments at the moment. And I think, leaves tax differences between sovereign reserves and people's holdings of these reserves need to be unpicked and unraveled. And that's going to take a hell of a lot of work from the accounting world, because the Big Four don't understand this stuff at all.
Josh, any closing thoughts?
Sure. I mean, I think we can just, if we look at that announcement just from the past month about the U.S. Marshals Service not knowing how much crypto it held, right? And reporting that it had lost control of multiple Ethereum wallets, as well as that it was tracking things, or has been tracking holdings on an Excel spreadsheet. We've got a long way to go. I will say there are certain bills that have been introduced, including the so-called Bitcoin Act, into Congress, which would sort of enshrine the Trump executive order, right? As Brian was mentioned earlier, the strategic reserve hasn't really been created till Congress acts. And I think one of the things that bill does, among many, in addition to providing for certain purchases in the future, it also says, Treasury, you're responsible for auditing this, and really puts them in the driver's seat, but also holds them responsible. So we'll see where we go with that. I would just say one thing, I guess maybe this is something I'm very focused on given certain deals that I'm working on, but I think just as an industry and various players, as we have increased secured lending and other sorts of very traditional activities, but in the digital asset space, is that understanding the rights that a customer has to his or her or its digital assets on a platform, depending on the type of wallet it's being held in, and whether it's omnibus or whether it's segregated.
Yeah,
Yep.
exactly.
Very important.
key.
That's fundamental. That's fundamental to all of this. That's why FTX happened. And if anyone looked where the SAF agreements were held with FTX, they certainly weren't sitting in Bahamas. You know, nobody ever reads this fine print, but the SAF agreements were not sitting in the Bahamas. And by the time they figured out they had a problem, everything had moved out via Turkey. So, you know, these things can be solved, but they take people like all of us from the industry to sit down with the regulators and the government and talk through, and with the technologists, because none of us have the answers unless we do it together.
Exactly.
No, totally agree. And I just would like to say 2018, the New York AG's office put out a report that was the world's first examination of global exchanges. And one of the things we pointed out in that report was the commingling of assets, and that it was going to be a mess and a huge issue. And here we are,
And here we
still picking up the pieces. All right. Well, thank you guys. It was a great conversation. It seemed rushed, but I hope everyone got some good information out of it. And please feel free to reach out to any of us at any time with any questions.
Did we have a question? We could probably take one.
No, we didn't have any questions that came up.
Thank you very much,
So,
Brian.
Thank you, everyone.
Thanks, Brian. Thanks, everyone. Have
Thanks,
a great
guys.
day or night or morning or whatever it is.